by Attorney Allen. Yeah.
Okay, all right.
Any reason we can't get the cases on here? Yeah, that would be good. It's this paper, you don't know what to bring, what not to bring.
Yeah, we're recording and confirm that by tapping the mic. It's going through, it's registering.
Okay.
And the recording is running and the time is running now.
Okay. Good evening, ladies and gentlemen. Welcome to the Rent Leveling Board of the City of Jersey City. Having been properly advertised in accordance with the sunshine laws of the state of New Jersey, on this date, 10/16/25, the meeting of the Jersey City Rent Leveling Board is called to order at 6:11 p.m. Can I have a roll call, please?
Chairman Danon Hill,
Present.
Vice Chair Sullivan Johnson III.
Here.
Commissioner James Eacock,
Present.
Commissioner Paul Revo.
Phil Revo,
Oh.
present.
Sorry, Commissioner Phil Revo.
Present.
Thank you, Commissioner.
There being a quorum of the board, the meeting will proceed. Thank you for attending our meeting tonight. Everyone will have an opportunity to speak. Please speak only when recognized by the chair to speak. Address the board, not your adversary. Keep your presentation to the issues in question. The board will listen to all sides of your complaint or application and come to a decision. All parties will receive a written decision in the mail. You will then have 45 days to appeal the decision to the Superior Court. So if you do not like our decision tonight, please be civil and appeal it when you receive it in writing. I count on your cooperation tonight. Are there any applications or for postponements of any matters tonight?
Chairman, we do not have any adjournments. We only have the three matters on. Is there any order you'd like to call?
Yes, since there's no cancellations, we're going to call 225 Duncan Avenue. Illegal rent petition.
Whoever's here, you're here? Okay, if you could just come up to the microphone. If you could speak into the microphone, just state your name and spell it for the record, please.
Okay. My name is Taylor Gospodarek. That's Tayler, last name Gospodarek, attorney with Northeast New Jersey Legal Services on behalf of the tenant who I have here today as well. We are here in response to an appeal by my adversary, who I don't believe is present.
I'm sorry, that is true. They did ask for an adjournment prior, and it was denied earlier today. There was no appearance by the property owner or their legal counsel.
If I could, I would like to still respond to all of the statements in the notice of appeal by my adversary, just to preserve the record. Okay. Beginning with the first point in the notice of appeal, the statement that the determination arbitrarily and without rational basis or adequate supporting proofs presumes no value of the tenant's work as superintendent. The tenant did act as superintendent in the building beginning in 1996, several months after she moved in. Therefore, her tenancy was not connected to her employment there, and then ceased working as superintendent in 2017. There has been no documentation, evidence, or otherwise of a rent arrangement in exchange for the tenant being superintendent. which is also stated in the revised Bureau of Rent Leveling Determination in July. I would also like to note that there was presumably an assumption of value by the landlord in their sole discretion when they increased my client's rent from $457 to $800 in 2018. And this is the overarching issue and basically why we're here today. Regarding the second point, that the determination arbitrarily and without rational basis improperly considers rents prior to the applicable statute of limitations, which, as stated, is 6 years, dating back from the date of filing. This was, again, already addressed by the Bureau, but I will still address it on the record. Again, the issue here is the rent increase in 2018, which is well within the 6 years if we go back from May 2023, which is when the application was filed by the tenant. Regarding the statement that the landlord or that we went beyond the statute of limitations, again, the Bureau addressed this by saying that the landlord failed to file annual landlord registration statements for 2015 to 2017, so therefore they had to use 2014. Again, regardless, we are here concerned about the illegal rent increase in 2018 from $457 to $800 and the subsequent increases annually thereafter. Regarding the point that the determination arbitrarily and without rational basis improperly added a party without service or obtaining jurisdiction, this is connected with the fourth point in my adversary's notice of appeal that says that the determination arbitrarily and without rational basis denied 225 Duncan LLC of a rehearing or an opportunity to be heard. As the exhibits show, there were emails between the property management company of the owner of the property at that time, K&S Management Group, on April 25th, 2025, clearly showing that they were actively participating in the investigation by the Bureau.
Mm-hmm.
Do you want me to continue?
Continue.
Yes.
Okay. Regardless, now that we are here actively appearing for the appeal, we are going to assume that my adversary is waiving that jurisdictional defense, given that we are, and they are fully participating in this. I do see that now my adversary is here, so would you like me to let him speak?
Your name again? I'm sorry, I just wanted to make sure.
Taylor.
Okay, thank you.
And I'll respond to any comments made as needed. Thank you.
Okay.
Should we ask her questions?
You want to ask a question?
Yeah.
Okay, sure.
One thing that's hard to determine in this file is the actual rents paid by the tenant and how they graduated. The tenant provided some evidence of their payments. So it seems starting on April 1st, 1996, it was 500, and then it seemed to continue to be 500 till August of 1996, and then it went to 400.
Correct.
So was this the time, did it go to 400 because she was the super then?
There's no actual agreement that states that, but it was that time that she began acting as superintendent, yes.
Okay, and then after that, we saw a lease in the file, that raised her rent to like 416, which would be the normal 4%.
Correct.
So, on that basis, we're looking at that as, say, where we're going to graduate from each time that a rent increase is assessed. It's going to go up 4% from 416 to whatever's next. But somewhere, it's not really in any kind of order, the receipts we have.
Okay.
But then it goes up to 457. We have a receipt of December 19, 2017. It's 457. And then there's a jump where the rents start to become, in 2019, $800. So is your tenant now paying $800?
My client has paid all of the increases up until she received this determination, which told her what her legal rent was supposed to be, and therefore she started paying the legal rent, which was just a few months ago, so this year. But she did pay all of the increases throughout the years, albeit the illegal increases.
Okay, because, yeah, you're not going to get to 800 in 2019 going up 4% a year.
So that's in our position, the crux of this issue is primarily in 2018 when, by only verbal means, no written notice, no offer of new lease, her rent was increased about $330 in 2018. And then thereafter, as you can see in the lease documents, it was within the 4%, but it's that one hike that obviously was an illegal rent increase, and then it was subsequent annual increases thereafter.
Okay, yeah, because there really is no paper trail to show us how'd they get to 800? There's no, it just doesn't follow from the start of the rent increases.
Correct.
Okay, so that, we just needed, I needed that background of,
Okay.
How we got here.
Yes, yeah, that is the gist of the issue I think that we're all here for today.
Okay.
Thank you.
Any other questions?
No.
Okay.
Counselor? Just state your name, spell it out, please.
Yes, Patrick Jordan, Patrick Jordan, for the respondent 225 Duncan LLC. 225 Duncan brought the application challenging the decision essentially because there was no dispute, including by admission in the petition for the overcharge, that the petitioner here was the superintendent of the unit prior to November 2017. And the prior decision, I think, reflected that because there was no written documentation supporting how much the rent was reduced as the result of her superintendent's services, the decision was based essentially on an assumption that the rent was only what was set forth in the lease. And then the increases, I think, as the board was just considering, wouldn't reach the $800 number that was established essentially upon the termination of her status as superintendent in November 2017. However, the implication that is created by that is there was no value of the tenant's work as superintendent. If no credit is given for the amount, the assumption is essentially that the value is zero. And the position that, among other, with respect to the decision itself, and I'll address in a moment the establishment of the rent later, but the decision itself, to the extent it assumed that the value of the superintendent's services was zero, was irrational because there had to be some value for it. I don't think either party would dispute otherwise that there must have been some value attached to it. So for that reason, it creates the question of, well, how is the rent properly established in the absence of any formal documentation establishing what the superintendent value was? And I think the board's decision properly acknowledged that some consideration ought be part of determining the rent based on the status of superintendent. It seemed to assume zero for lack of anything else. I think here, notably, the tenancies existed for a very long time. This isn't somebody who took possession even shortly before this employment status was terminated in November of 2017. The tenant occupied the apartment since 1996 or 1998, I believe. But the effect of that is that during that period of time, she's not just a tenant in the apartment. And even the Anti-Eviction Act, for purposes of protections under New Jersey state law, acknowledge that somebody acting as an employee or superintendent, or when a tenancy is conditioned on employment, there's special consideration given to that. It provides a grounds for terminating the tenancy upon the termination of employment, which is a remedy that would ordinarily not be available to a property owner trying to dispossess somebody from a unit. And the idea is that but for this employment status, this tenancy wouldn't exist. So therefore, at the termination of the employment status, there's an opportunity for the owner to essentially start fresh. They can, based on the termination of the employment status alone, recover possession of the unit. For the purposes of the Jersey City Rent Ordinance, I think part of the definitions about what is subject to the jurisdiction of the rent control ordinance actually answers the question about what the status is and what the takeaway is from somebody's prior employment. Because the code doesn't specifically address the issue of, well, what happens if an extremely low, below market or otherwise, a rent that otherwise wouldn't be offered or established but for employment is terminated. So the code sets forth that the rent control ordinance is subject to what the Act defines as dwelling units in certain circumstances, and then that's under Section 260-1. And then within dwelling unit, it speaks to certain tenant occupancies. So I think here what we're looking at up until 2017 is something that's just outside of the rent regulation. And in certain circumstances, that might just be presumed because it's a unit occupied by a superintendent. I think the board could take notice that often there is no rent paid with a superintendent apartment. Sometimes there is some, and often that's going to be dictated by probably the size of the building and the amount of additional duties that would be imposed pursuant to the tenancy. Here there was some consideration in addition to the mere duties of superintendent. Nevertheless, the point is that she's not just a tenant. And if she's not just a tenant, then that's going to take the unit outside the definition of a dwelling under the code and outside the jurisdiction of the rent control ordinance in general. The unit is essentially something that is not subject to the rent leveling ordinance until she becomes a tenant. And she becomes a tenant when she ceases to be an employee. And she ceases to be an employee in November of 2017. So our view of it is that that's essentially the initial rent. And to the extent that we're looking for something to establish or a methodology to establish how to determine her rent when she first becomes a tenant, the code, again, it doesn't specifically deal with the status or situation in which somebody's status as previously an employee is then terminated, but there are analogous circumstances where rents are established in the absence of an ordinary increase. And there's really two. One is how the rents were established when the code was first enacted in 1983, and then also when a unit is moved from an otherwise exempt status. So when a unit's removed from an otherwise exempt status, the code deals with that under, it's part of 260-1, any new dwelling or housing space being rented for the first time for the initial rent only. I think that's probably the closest here definitionally to what's happening. Because without her being solely a tenant pursuant to the code, the units, although it's not enumerated, essentially exempt. And there might be other circumstances where a unit that might otherwise be regulated is occupied by somebody who might not qualify for the protections of the Jersey City Rent Ordinance. One, for example, might be if it was occupied by a squatter or something like that, where there's no landlord tenancy at all established. Here, there's employment status, and part of the employment compensation is occupancy of the unit. But that's not just a tenant, at least not as contemplated by the rent code. So for that reason, we'd say it's analogous to an exempt unit, like otherwise another example might be a unit that was previously public housing regulated or something, and it becomes removed from that exemption. And then the first rent that's charged upon being removed from the exempt status becomes the rent. So here that would be the rent that was established in 2017 when she started her tenancy, essentially, when she ceased her employment status and started her tenancy. So that would be the initial rent when the unit ceased to be exempt. And the methodology for that is not arbitrary, and it's contemplated by the code when a unit that was previously exempt comes on into regulated status. We also would say, in the absence of anything else, at a minimum it would be more intuitive and in line with other parts of the code if the rents were established at least by a comp or a comparable unit. And that's what the code contemplated initially upon its enactment, did when the, quote, base rents were not possible to determine under the base rent definition. Addressing that situation, the code reads, if sufficient evidence is available from which the rent leveling administrator or board can determine legal rent charged or actually received as provided above, then the rent leveling administrator and board have the power to determine the legal base rent by considering the legal base rent of other units subject to the provisions of this chapter, which are comparable in size, location, and facilities to the subject unit. The other units in this building generally are leased for above the $800, and which is not unusual for an apartment like this in this area. I think the...
Excuse me, Counselor.
Yes.
1 minute left, please.
Sure. I think some of the other monthly rents are in the amounts of $1,345 for Unit 1S, $1,994, $1,752 for Unit 4, $2,119 for Unit 5, and $1,700 for Unit 6. So again, in summary, we would say the unit is essentially removed from the definition of really a dwelling because she wasn't a tenant prior to her termination as an employee. She became a tenant, and the unit became subject to the rent ordinance in 2017 when she was only a tenant, as contemplated by the code. And to establish the rent at that time, we'd insist that the most intuitive way to do it would be to treat it as an exempt unit before that, and that the initial rent she was paying after she became just a tenant establishes the rent here in the $800 number. Or in the absence of that, if the board was looking for some kind of base date, it ought not look back to some old rent from 2014 that also may be subject to when she was still acting as an employee, but should look to comps, as was contemplated by how the board would determine base rents in the absence of other evidence when the code was enacted.
Okay, thank you, Counselor.
Yes, for the transcriptionist, this is Sullivan Johnson. We just want to make sure that we can identify ourselves. I do have one question, Counselor, and regarding the rent registration document, is there a particular reason why that wasn't submitted?
I'm not sure. I'm not sure why the rent registration wouldn't have been submitted. We don't argue that they wouldn't have been subject to the registration since 2017. We can see that they would. Prior to that, if they, to the extent they did register, I'm sure they were doing so in observance of what they thought their obligations were under the code, but nevertheless, because this is an employment situation, we'd submit that they, in fact, were exempt at that time.
Anybody else? Any questions?
James Eacock, I don't understand how Miss Jackson is considered an employee because her rent was initially started at $500. Then it looks like she got a discount to $400, where $100 would supposedly be the compensation for being the landlord. So is she 80% tenant, 20% employee? It doesn't seem like that, it would be fair to just say she's an employee, but she's still paying 80% of the rent.
Right. So that develops the problem. I would agree. It's unclear on that where the line is exactly. But this is what she's not. It seems she doesn't seem to be a tenant as contemplated by the code who's merely paying rent. Her consideration for occupancy here was some combination of a payment and services. And the value of that together, as compared to a tenant who's just routinely paying rent, is an apples to oranges comparison. Again, I would point to the instances where if this was, as in many cases, the apartment occupied by a superintendent who is paying no rent, it seems like it would defy logic to say, well, the rent is going to be 4% of an increase off zero after her employment status is terminated, because then it's going to perpetually be zero. It would seem probably irrational if it was extremely low, if she was paying some nominal amount, $100 a month, meanwhile servicing a very large building. But because it's an apples to oranges comparison, it is essentially, I would submit that that's the problem. It's undefined in terms of how it would fit into the code. Quite literally, it's undefined as dwelling unit is defined in the code, which is what subjects it to the jurisdiction of the rent control ordinance. I don't think by saying removing her as a tenant definitionally and exempting the unit up until the time she's solely a tenant creates any foul precedent. It's probably going to be an unusual situation where that occurs, not the least of which because if something isn't routinely negotiated, possession would otherwise be, or at least the owner of the building would otherwise be entitled to recover possession. In fact, to hold the owner of the building to this could create a disincentive in the instances where somebody might be working as an employee of the building for the property owner to take no chances. I'm not going to take chances going forward about what the rent's going to be established at rent control. This person wants to continue to live here. I would make a deal with them to establish the rent after they're no longer going to be superintendent because we no longer need those services or we've hired somebody else, but I'm not going to take my chances. I'm just going to seek dispossession here so that I don't have to worry about the status of what the rent's going to be and I'm going to be sandbagged with an overcharge claim later. I think that would be against public policy. Here, the property owner already elected not to take that route. They elected to continue on when they otherwise might not have had to with a tenancy based on generally a reasonable rent. This wasn't a wild rent that was in gross excess of what would have otherwise been collectible for the unit, and it's below even what the other units in the building were for the comp, substantially so. And I think for that reason, that's most often going to be the situation if somebody's removed from an employment status and then tenancy is created. They're going to either agree to an initial rent from a unit that was exempt previously, which the code specifically contemplates, or the parties aren't going to agree, and then the unit will probably be vacant after that.
Follow-up, James Eacock. What we didn't see in the file are a few things. Well, there's no employment contract. And then the point about, in 2017, it seemed like they wanted Miss Jackson to vacate. But then we never saw, any more, we didn't see enough documentation after that to establish, well, obviously she didn't leave. And, then what was the next, like the next leases we have, I think come from the new ownership or current ownership. So there's this gap from like 2017 to 2023, I believe. So, again, how do we fill this gap? There's no, we're talking about a lot of things that we have no evidence or no documentation for.
I understand the perceived inconsistency there, but I think I might be able to illuminate it insofar as that the notices that were sent purport to terminate the tenancy in some capacity. That would have been routinely done and is required even in certain circumstances where the parties expect the tenancy to continue pursuant to the terms of the Anti-Eviction Act. One place that would routinely be seen is if a property owner seeks to increase rent by a certain amount by notice. The statute, the Anti-Eviction Act does provide for that under 2A18-61.1F, but in order to do so, the notice, which is often informally referred to as a notice of rent increase, must, for purposes of case law in New Jersey, also terminate the current existing tenancy and then set a new rent essentially at a holdover rate. Similarly here, where there was questions about whether or not there was an employment status beforehand, in order to preserve their rights and also satisfy any requirements they would have had to, if they needed to, proceed with a possessory action based on the termination of the employment, the notice would have had to read that way and did so here. And I think it was Mr. Salerno's notice, probably an observation of that part of the statute that said, well, whatever's going to happen next, for us to take that next step, we need to make sure statutorily we've satisfied our requirements of saying the employment status is terminated and the old terms of the tenancy are terminated. I think the gap in time is actually informed by what happened, which is that after the termination of the employment by notice, which, yes, also purported to terminate this tenancy, but it would have had to do so in order for them to set terms going forward. It was the gap is filled in by the payment of rent at the $800 rate, which I think is acknowledged happened after that. And I think everybody was satisfied. The petitioner here for a long time remained in the apartment paying that rate, and the owner of the building took no other action. I think the lease was ultimately not executed, but I think there was, it's not subject to the statute of fraud, so it wouldn't be required to be in writing, and I think the tenancy was established at that rate at that point. So I don't, although it would have been nicer if everybody executed a lease so it completely formalized everything, I think the circumstances are explained between the statute and also the course of conduct of the parties in paying the rent, remaining in occupancy, and no other issues being created during that period of time.
Yeah, I don't believe we saw a lease for 800, but then the later leases, I guess, built on the 800.
Yeah, I think what the owner had tried to do at that point was they said, well, we have a tenancy established at this $800 number, now we'd be entitled to take our 4% increases off of that, even though they didn't have an initial lease. If that didn't meet regulatory compliance as to the increases that would be available under the code at that rate, we acknowledged that if they didn't register for that time, there might have been an overcharge for that amount if it was paid after that time. But purely for the regulatory problem of the subsequent rents not being registered after the establishment of the initial rent, which again seems to have been acknowledged by the parties by an occupancy and tenancy that continued for some years at this rate where it was paid and no objection was made without issue.
Any more questions?
Yeah. Hi, Phil Revo. I'm a new member to the Rent Leveling Board.
Press the mic.
Press it. That proves I'm a new member of the Rent Leveling Board. My name is Phil Revo. Thank you for everyone for being here. And I pardon if I ask questions that aren't supposed to be asked. But what I see is Miss Jackson was paying $476 1 month, and the next month she's paying $800. Whether we assume this, whether it's a good rent because other people are paying $1,300, $1,800, whatever, that's a heck of a lot more than a 4% increase. And also, instead of this boilerplate one-page lease, it should have, if you're fortunate enough to own buildings and have a house on Gifford, you should know that you should say what you're paying Miss Jackson for the work. And there's no proof, unless I missed it, of employment. So to say she wasn't paying rent. Am I allowed to ask Miss Jackson a question? No? Okay. Was the landlady receiving $450? Was she receiving money from Miss Jackson every month?
So 225 Duncan wasn't owning the building at the time that the employment status commenced. So the details about what it was exchanged between the parties at the inception of her status doing this work up until 2017, I wouldn't be able to speak to specifically. In terms of the bareness of the record, in terms of what were the terms, there isn't much, it seems. I'm not sure, again, what the owner at the time had contemplated, and we, of course, weren't privy to those discussions. But I think there's enough in the record, just really by way of the petitioner's initial application, to establish that she was working there in some capacity. She, in fact, volunteered that information when she commenced the claim. So I don't think it's an issue of whether or not she was or wasn't working there. In terms of the magnitude of, well, is this enough work to, say, make her something less than a tenant or not? Again, I agree that's where I think most of the indefiniteness and the uncertainty about this arises from. Because if it was a circumstance where it was a superintendent employment where her rent was zero, I think it would be a little more intuitive to say, well, of course it can't continue to be zero if she's no longer the superintendent. We have part of the Anti-Eviction Act in New Jersey, which does make a distinction between these two things, a typical tenancy and where someone's employed. And the rents aren't going to be increased off of 4% of zero for the simple reason that the mathematics would reveal that there's never going to be any rent for this apartment. That indefiniteness exactly creates the problem here. But for us, we would say that, well, it is explained, at least implicitly, by the code. The code is something that is a municipal law that is in derogation of the common law. So we would say that it ought to be strictly construed to its terms. And it speaks to tenancies. Or I shouldn't say tenancies, tenants. And a tenant is somebody who's occupying a property in consideration of rent or for a rent. That's not the only thing that was being exchanged here in consideration for the occupancy. It was some mix of the two. It was some mix of rent and a payment. It seems to be at the low end, but maybe it wasn't as much at the low end when her tenancy started. That's something we could consider as well. But the fact that it's, I would say, too indefinite to clearly define, again, takes it out of that definition of tenant and dwelling unit under the code. And for that reason, it's essentially not covered, and it should be treated like an exemption for that reason. To do so otherwise, I think it's not contemplated by the code. It doesn't fit into any construction of the code, including any of the two methodologies for remedying a situation where it's unclear as to what rent ought to be. For example, when a unit is removed from an other exempt scenario, or at the inception of the Jersey City rent control ordinance, and it would create a disincentive for parties when they want to agree on a tenancy after employment to do so. Because it could create a circumstance where, well, now it's just an insurance policy so that there's not a massive unknown overcharge claim growing. A property owner might say, well, we all like each other. We want to continue this. We're the superintendent services or the maintenance services, whatever the case may be, where they're being contracted out now or something else. We'd like to continue this with you, but we can't because we don't know how we can resolve the rent claim. And it would be a difficult problem to do because as far as I would.
So 1 minute, please. Please, 1 minute.
Yeah, we would submit that you can't just settle a legal rent. It would affect parties beyond the scope of a settlement. So it would make it a very difficult problem to resolve, even by a stipulation between the parties, because you can't affect the legal rent going forward for everybody else in the world just by settlement between the two parties at the table. For that reason, we think the most readily available remedy here would be to say, well, this wasn't really a tenancy, at least not as contemplated by the code. So it was an exempt unit before then. It became covered by the code when she became only a tenant. And the parties could agree to establish a rent at that time or not and go their separate ways. Here they elected to do so and did so for some time without issue.
Thank you. Thank you.
Thank you.
Just one question, James Eacock again. As my colleague, Mr. Revo, mentioned, we still have difficulty in making up the jump from 457 to 800, where we have, no documentation, no rent rolls. So I'd like to ask the Bureau, how did you, how do you address this?
Do you want to call the hearing officer up?
Yes.
Okay, are you done with the questions with the council then?
Yes, done with the council.
Thank you.
Thank you.
Good evening. Yes.
Okay, Director Chiron Richardson, please state your name for the record.
Director Chiron Richardson, SHYRONE RICHARDSON.
Okay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Thank you. All right. So to answer your questions, so as we see tonight, if you look at the determination, normally we would go back 6 years. We went back and forth with them several occasions versus email trying to get rent rolls because we needed rent rolls to establish what was the base rent at that time. We got nothing. We sent them an email and said, listen, we don't get anything, and this was weeks that we're going to have to go to the most current rent roll that we have was 2014. Also, based on what he said, now what he's not saying is that any year that we don't have a rent roll, you do not qualify for an increase. Those years that you see going from 2014, what could have happened, you have permitted rent. So even though you have permitted rent could be what you can charge versus what you are charging. So those years that we had rent rolls, that permitted rent could have went up every year. So let's just say from the 500, every year they could have got the CPI, even though they didn't charge her that. So that was what they would have been permitted to charge. But because there was no rent rolls, they didn't get that. Did not get that increase. Again, as you're saying. So, and the other thing that we did establish that, it's evident because this notice to quit that there was some provision made when she was the superintendent, but we reached out to them several times to say, okay, we have no documentation because even in the rent roll, you could have had, this is her rent because she's an employee, but this is what she would be paying. But there was nothing that said she got any discount. And as the counselor said, she was paying some rent. So it's not, you can't make up numbers that don't exist. If she was paying zero, I know zero from zero is nothing, but she was paying something. And that something could have been going up every year as a permitted rent had they just submitted the rent rolls. So based on the evidence that we have, and to be honest, those years that we have no rent rolls, any apartment in there, if they increase their rent that year, that's illegal. We just don't have a petition from those people. So if those people find out and they submit a petition, we can actually say that we go back and we see these years, there was no rent roll submitted, so you do not get the CPI for those years. So that means that there's some other apartments in there that may be charging illegal rents because we have no rent rolls.
Right.
Okay. No, that's the only
Okay.
methodology you could use.
Absolutely.
Okay.
All right. Thank you.
Thank you. Thank you. Counselor, you want to speak? Yes. Okay. Dana Hill, Chairman. 2 minutes, please.
Okay, thank you. I just want to,
For the record, can you just mention your name just so
yes,
the trans-
Taylor Gospodarek on behalf of Tenant again. I do want to put on the record there's been some miscommunication. The tenant started as solely a tenant in April of 1996. In August of 1996, she began working as a superintendent. The allegation that those two are tied and therefore termination of her employment in the building would have given grounds to therefore evict her is therefore not valid. They were independent. She was a tenant solely first. Also, there was an attempt to evict her in 2017 via the court system. It was denied or it was dismissed. The tenant can testify that if she would like, if you need more information. But after those notice to quits that were sent, the landlord did try to evict her. Again, it was dismissed. That's why she remained in the building. So I just want to put on record that the employment was not tied to the tenancy. And that is it.
Okay.
Any questions?
Thank you. Motion to close the public portion of the meeting.
Okay, I have a motion from Chairman Hill to close the public portion of this meeting. Do I have a second?
Second.
Second from Vice Chair. All in favor?
Aye.
Somebody want to read it off?
Oh, I'm sorry. Yeah, name all of them. Oh, okay.
Okay.
So sorry. For the record, that was Vice Chair Sullivan Johnson, Chairman Danon Hill, Commissioner James Eacock, and Commissioner Phil Revo.
Okay. So you want to read them?
Again, you have to speak into the microphone.
Oh, yeah.
Make sure that everything's on the record.
Okay. I'm gonna read them.
Anyone have a motion?
Anybody has a motion? You want to? It's going to be between you two.
Okay. Commissioner Sullivan Johnson, after hearing the testimonies that have been presented this evening and taking in consideration Statute 260-3 regarding allowable increases, in my opinion, I don't think that the requirements have been fully met. And the requirements are established for a reason. And I also do believe that in this instance, if we have a landlord, that to me is, I think it's just reasonable to assume that the landlord has a lot more control on tenancy than a tenant, and in establishing what is going to take place with that particular tenancy. And given that this particular statute, 260-3, does require, the registration of the rent roll, which was not supplied, and based upon the testimony that was submitted, there was a failure in responding to certain communications. I just believe that the recommendations presented by the Bureau of a rent increase of a rent establishment of $531 is appropriate, and that's the position I would personally take.
So do we have a motion?
Motion-
Just
motion-
motion
motion.
to.
Motion to accept the hearing officers.
Okay, I have a motion to accept the hearing officer's
decision.
determination
Right.
by Chairman Hill. Do I have a second?
Second.
Okay, I have a second from James Eacock. Roll call for the vote. Chairman Danon Hill,
Yes.
Vice Chairman Sullivan C. Johnson III,
Yes.
Commissioner James Eacock,
Yes.
okay, Commissioner Philip Revo.
Yes.
Okay. The motion to accept the hearing officer's determination unanimously passes.
Thank you. Thank you.
Thank you.
right.
Next case.
Next
if
case
preference?
is.
I have health reason. Can I run to the
ahead,
restroom?
go ahead.
I'm sorry.
Need a-
We'll take a
so we- recess?
Yeah, just a quick sec. 2 minutes, 2-minute recess, please.
Okay.
way too many blanks.
Have a good night.
Hey, Tom.
Do you want to do 235 next, because the gentleman's here for 235 and nobody's here for 231?
Yeah.
Okay. Yeah, you're good. Yeah, that's what, okay.
What happened to your masterwork? Usually you do a nice spreadsheet. See it in the front. By room and
That's my fault, I didn't give it to Ori to attach.
Oh,
And
okay.
I'll explain
So,
that.
all right, please, here.
Because I accepted what the applicant had. The room count was, I did the room count and I did the calculation and his was correct.
He's 231.
You're 235, right? Yeah, 235.
Five may have had this, 90, something like that. Is that a thing? Is that 235 that actually had his request? Like number of rooms, I guess it's 3 rooms. And so he wanted a 90.
Oh, this is, this, no, this should have been, it probably just wasn't copied and attached. This should have
Right. I copied it from both. I took it because I said, when I read it and I saw it, I said, this gotta be for it, because it's the same.
Yes.
Usually, I like the way it's laid out.
Yeah, that's, yeah, I'm sorry.
But that can go for both, right?
Well, this one's 235, the dollar amounts are different.
Because the other one is 27,
Yes,
36.
yes. Yeah, this document should have been in 231.
In 231,
Yeah, I
right.
don't know why it wasn't.
But it wasn't. But I saw it written out, so.
It just, yeah, it wasn't copied. I don't know what happened.
Can we accept the conclusion, but still put a qualifier in? We need to schedule a pub room or something like that. Like, it has to be done. I think I might say that it has to be done according to the schedule of pub room per apartment. Yeah, just trying to figure out how to work around the new schedule. Okay.
I asked them to use it.
Let's get on it. Tom, you talking about this one? Right? That's really quick.
A puzzle with a lot of missing pieces.
Yeah, that, she did nothing wrong. I mean, you know,
531 is
Cheap.
ridiculously cheap.
but that's besides the
And
point.
she was willing to pay 800, but we can't prove that.
Yeah.
Okay, we ready? Okay. Next case is 235 Lexington Avenue, capital improvement application.
Yes, so we have the property owner present, Mr. Lou Rinaldi, and the hearing officer, Chief Inspector Tom Colleen.
Let me hear from,
If you could put the microphone on. Yeah.
let me hear from the landlord real quick.
Okay.
No, I mean real quick, but
If you
Chairman
please, Mr.
Dana Hill
Rinaldi.
requesting the landlord.
Mr. Rinaldi, if you could just place your name on the record and just spell it for us.
Okay, this is Lou Rinaldi, Louis, Rinaldi.
Okay, if you could just raise your right hand, please. Okay, Mr. Rinaldi, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Okay, see.
It's just as an overview, I've owned the building for 15 years or so. When we first got the building, we did a lot of improvements on the inside. We didn't do any improvements on the outside of the building. So we kind of carried that. So last year, it came to the point that things, we had the capital to do it, and we did the improvements. So basically, we did a lot of improvements on the outside, on the facade of the building, the roof, security improvements, fire escape improvements, all these other things that we did on the outside of the building. And this is the request that I'm putting through.
Now, these buildings are off the corner of Mallory, right?
Yes.
A little bit down, a little bit.
Yeah, I think my building is,
Left-hand side or right-hand side going down?
we're on the left-hand side. If you go in from Mallory.
Okay. Okay. Any questions anybody have for him?
No.
Thank you, sir. Can we hear from the hearing officer?
Okay, Tom, if you could just place your name on the record and spell it for us.
Thomas Killeen, Thomas Killeen.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, Tom.
Okay. Just can you tell us a little bit about the services that were provided by
Right.
the landlord?
Okay, so with this building, there was an entire new roof was installed. They ripped out the old roof, put in the new roof. They did all new window lintels, which are the the cement sections that are right above windows. They also did upgrades to the fire escape, new security systems, and there was also pointing and cement work done to the exterior of the building,
That's what it is.
which are all beneficial to the operation of the entire building.
Building, okay. He said there was security also that was done. Was it
Yes, security cameras installed.
Security cameras installed also, okay.
And this came up to $71,720.16. The work was all inspected. It was, it was performed as described.
Okay. Anybody have any questions?
James Eacock, as discussed, we don't know, the allocation of the full capital improvement wasn't provided in the file.
Yes. Yeah, that is my fault in preparing with Ori what should have come to you, gentlemen, because I don't see it here in mine. The room count is as described in the application on page 1, where there are three room apartments and a 4-room apartment, and, I'm sorry, 4 3-room and 2 4-room apartments, and the calculations of the amount increase is the same as the applicant has requested. Normally, there was another form, which I do not see in here, which is our form, which basically says that that's the number of rooms that were counted, and the increase is per room, the dollar amount. That form is not in this particular file.
Yeah, if I could, to rent leveling administrator Eric Bulwith. That is Bulwith. First name is Eric. Oh yeah, I'm sorry.
Itza Wilson, attorney for the board. Eric, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
I do. Okay, so yeah, when the base rents and the actual rents are questionable along with the increases, the Bureau of Rent Leveling will do a calculation. I mean, we're going to do one either way, just to confirm. But in this case, the rent rolls were submitted every year. There wasn't any question to the numbers that were applied to the application. So we are not questioning the application in that way. In fact, I'm talking just about the rents, but in the increases, I can't speak for Tom, but he's not questioning it either.
Okay.
So, sorry, I wanted to kind of put that out there.
Thank you.
Yeah.
Thank you.
Clear the record.
Any That's it.
Just one question, Eric. James Eacock, just one question on, just the process of how we can go about this. Now, so we can accept that there is sufficient evidence based on Tom's work that the statutes have been met and the capital improvement should be accepted. But is that all, as a matter of course, is that all we need to do without understanding how, the allocation to each apartment?
So the allocation, I believe, is on the application, right? That was
Yes.
okay. I'm sorry, Eric Bulwith.
I understand what the commissioner is saying. It's not broken down. It's just the number of rooms and then the total amount of the increase. There's a form that you're referring to that should have been in the application that says the increase is, and I'm arbitrarily saying this, $9, $15 per room. And that form happens to be missing from the file. But my numbers do match the applicant's numbers on his application.
So again, the Eric Bulwith again. The Bureau is not questioning the allocation based on the numbers that we were provided. Again, if we did, we would have supplied that, and it would have countered what the application is stating. also makes the file a lot lighter and less paper for sure. But again, for future reference, the bureau can definitely do that and just have that own calculation, and then just for future reference, if you guys require that, that's fine.
Okay.
Yeah.
Okay.
Okay, thank you. Motion to close. Oh,
The board, I just wanted to know if you have any other questions or you have questions of myself with respect to Mr. Ecox, your question as to how to allocate or how the board should, I guess, rule based upon not having the documentation that indicates what the allocations of rent is supposed to be.
Yeah, my question would be, can we, since it appears from the evidence in the file and everything else that the burden that the landlord had to meet for section 260-5E4 has been met, so we can agree, make a motion that accepts the full, the total sum of the capital improvement, but we can't make any comment on the allocation.
Right, maybe
Right.
you can
We'll just comment on the total.
comment on the total and you can maybe remand it back to the Bureau for the calculation based upon your decision tonight. Okay?
Okay, thank you.
okay, motion to close the public portion.
A motion from the chair to close the public portion of this hearing. Do I have a second?
Second.
Sullivan,
Oh,
Okay, I think ECOC might have beat you out, so I'll have Commissioner ECOC down. Okay, all in favor?
Aye.
Please.
Aye.
Okay, that was Sullivan, Hill, ECOC, and Revo. Okay,
Okay,
public portion is closed.
public portion is closed. Motion to adopt the hearing officer's determination.
okay. Yeah,
Okay, I have a motion.
we have a motion to accept the hearing officer's recommendation for the total capital improvement work in the sum of $71,720.16, this total sum constitutes the major capital improvements which are defined in the rent control ordinance in section 260-5E, parentheses 4. So we agree on the total amount, but we need to remand back to the Bureau for the breakdown of the allocation.
Okay, so there is a motion to remand the application back to the Bureau of Rent Leveling for another hearing to provide you with the confirmed allocating of the increases. It's a
No,
motion to remand. Right?
Yeah, let's strike the remand.
Okay.
I think we'll just
Motion
make a
struck.
motion to accept the hearing officer's recommendation that the landlord has proven that it has done capital improvement work in the total sum of $71,720.16, and this total sum is in accordance with the rent control ordinance in section 260-5E, parentheses 4.
To sorry, I'm just getting.
If we could read that into the record if necessary.
So, okay, so 260-5E4, which states major capital improvements shall consist of a substantial change in the housing accommodations such as would materially increase the rent value in a normal market and which consists of capital improvements to building-wide operating systems, including but not limited to items such as complete plumbing, electrical replacement of the entire building, or a new roof. Major capital improvements shall also include complete kitchen, bathroom replacements for an individual apartment unit. So the motion is to accept the hearing officer's
Determine.
recommendation.
Yes.
Okay. And that's from, that motion is from Commissioner Eacock. Do I have a second?
Have a second.
Second, Sullivan Johnson.
Okay. I have a second from Vice Chair Sullivan Johnson. We're going to have a roll call. Roll call to accept the motion, for the motion to accept the hearing officer's recommendation. Chairman Danon Hill,
Yes.
Vice Chairman Sullivan C. Johnson III.
Yes.
If you could, into the microphone.
Yes.
Okay. Commissioner James Eacock
Yes.
and Commissioner Philip Revo.
Yes.
Okay, thank you. The motion passes unanimously. 4 to none. So we'll call the next case.
The next case, 231, is not here.
Correct. No one has appeared for 231 tenants or property owner. Would
So-
you like to speak to the hearing officer?
Yes.
Okay. Tom, you're still under oath.
Thomas Colleen.
Yes. 231 Lexington Avenue, capital improvement.
This particular building was just a roof replacement,
Okay.
which was inspected and verified. At the hearing for this particular building, no tenants came to object to the increase. And there is the form with the breakdown per room, which was missing in the other application, where it comes out to $9 per room, per apartment, for a total of the one bedrooms are, the 3 bedrooms are 27 and the 4 bedrooms are 36 increase. That's the form that was missing from the other application.
Okay. Any questions?
Nope.
Okay, motion to close.
I have a motion to close from Chairman Danon Hill. Do I have a second?
Second.
Okay, second by Commissioner James Eacock to close the public portion of the hearing. May I have a unanimous vote by stating aye?
Aye.
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 Okay, that was Commissioner Sullivan, Commissioner Hill, Commissioner Eacock, and Commissioner Revo. Okay,
Motion to accept the hearing officer's recommendation for 231 Lexington Avenue capital improvement.
okay, I have a motion from Chairman Hill to accept. Sorry,
Oh, I'm sorry.
I'm sorry. Go ahead.
The amount for 3-bedroom, $9. I'm sorry. Wait.
Want to do the total?
The total. I don't have the total.
Here you go.
The total. I gotta take my
Just
glasses off.
1 second will be
It's 20.
22,500.
Okay. In summary, to accept the total major capital improvement of 22,500 be accepted, depreciated over 10 years and allocated to each apartment based on the number of rooms in the apartment as set forth on the attached schedule.
Okay, so I have a motion from Chairman Hill to accept the hearing officer's recommendation based on the improvement amount of $22,500 to be allocated to each unit per room for the next 10 years as a major capital improvement. Do I have a second?
Second.
I'm
Sullivan
going to give it
Johnson.
to Eacock again. Commissioner Eacock. I have a second from Commissioner Eacock. We're going to have a roll call now to accept the hearing officer's recommendation. Chairman Danon Hill.
Yes.
Okay. Vice Chairman Sullivan C. Johnson III.
Yes. Yes.
Commissioner James Eacock.
Yes.
Commissioner Philip Revo.
Yes.
Okay. That motion passes unanimously. Do I have a motion to adjourn?
Motion to adjourn tonight's meeting.
Okay, I have a motion to adjourn tonight's meeting from Chairman Hill. Do I have a second?
Seconded, yeah, at 7:20 p.m.
Sure. Okay, seconded, and we have marked the time for the record. All in favor?
Aye.
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 Okay, all commissioners rule in favor. It's Vice Chair Sullivan Johnson, Chairman Danon Hill, Commissioner James Eacock, and Commissioner Philip Revo. Thank you. Good night.
Thank you. Thank you.
Thanks, Tom.
I'm sorry about that.
Oh, that's all right.
Bill.
Make sure we go through the.
Welcome aboard.
Yeah, it was fun.
Right? Welcome aboard.
Yeah, no problem. No problem, Tom. Yeah, that's good.
Mr. Eacock is not going to,
No, listen,